Hi, thank you for joining our webinar today. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the wonderful Chris Grady, a Washington construction lien law expert. Today's webinar topic is a contractors, subcontractors, and suppliers step-by-step guide to getting paid. So without further ado, I would like to introduce the fabulous Chris Grady.
Oh, well, thank you, Jesse. Hello, everybody. My name is Chris Grady, and I'm an attorney at Aldrich Goldstein, a Washington lawyer. I actually work in Portland, where the Columbia River borders Oregon and Washington, and I am here to present Washington lien law today. A little bit of background. I have worked in the construction law practice, specifically in this firm since 2010, and I've been an attorney since 2006. So I've had a lot of experience in helping all parties to a construction project, every single, aspect of it, from contracting to litigating. And so I have a perspective that I'd like to share with you as we go through these things and we talk about how to get paid. And we're here, of course, specifically to talk about liens and bonds today. And as we go through the topics today, if you have any questions, there's a chat box on the right, and then we'll try to answer those questions at the end. Please don't include names or company names in the questions. So our agenda today, we're going to talk about contracts because really that's the basis that's the core, that's the origin of how you get paid. We're going to talk about confusing and very specific lien steps, laws, and rights today, and statutory requirements. But really, you got to start with your contract. We'll talk about that. We're going to talk about securing your lien rights and the big picture view of some of the steps you need to take to do so. Same with bond rights. We're going to talk about some rules and exceptions, some traps for lien laws, and there's lots of tricky things in there, even for the lawyers. And then we're going to talk about the right way to exchange or release for a check. So the construction contract, really the first thing you need to do is know your contract. You may have your own forms that you're able to use in your relationships. You may be able to negotiate contracts in your projects from project to project. You may receive a contract if you have a relationship where the other contracting party may have some more economic power and you may have to accept terms. But no matter which way you go, you definitely want to read your contract and know your contract. And to the extent that you're going to be able to do your own contract, you're going to want to make sure, or you're going to want to make sure these things are in the contract if they're not in the contract presented to you. Basic information, and that's parties, which includes ownership and entity names, authority to make and execute decisions. You're going to want to have a description of the project, address, owner information. You're going to want to especially put price and payment terms in there, and that because that's going to be one of the core disputes. If you're going to progress to trying to enforce your lien rights, and if you're going to get lawyers involved, the price and payment terms are going to become probably most of the focus of your dispute. And so getting ready in the beginning, before you even start your project, and planning and discussing and making sure you're clear on price and payment terms is going to go a long way for you. And in fact, it may cause you to avoid having to enforce lien rights when you set up your contract clearly in the first place. And that would be my advice to everybody today is to, you want lien rights are extremely important. It's a powerful tool. But, if you can really set yourself up properly at the beginning of a project, you're going to minimize your chances of having to go through that process. So you want to define what kind of pricing you have. In Washington, there are, and I'll talk about this a little bit more, there are called what are called pay if paid or pay when paid provisions, and those are dangerous ones that could potentially affect your lien rights. So you want to be careful about those things. Schedule is extremely important. That can have a big impact on when you get paid, can have a big impact on the timing of your lien rights, and it can also have a big impact on disputes about who's responsible for delays. Scope of work, that's another key term in your contract, which again is part of why am I here today? We're here today to set up your lien rights. And in your contract, you want to have a clearly defined scope of work, because if you're at the phase of a payment dispute with your contracting partner, there's going to probably be arguments about what is in or what is out of scope of work. So clearly defining your scope of work up front. And then also as it changes, clearly defining changes during the project through contracted change orders is really important if you want to be able to set up your lien rights properly. So what's the one change that I like to talk to folks about in a construction contract that maybe you haven't thought about? Well, and again, all contracting parties are going to be in different positions. So you have a developer, you have an owner, you have a general contractor, a subcontractor, sub-tier subcontractors, or any combination of the above in a project. And each one of those parties is going to have a different point of view. So it's kind of hard to give you one piece of information that applies to all. But I would say that let's look out for attorney fees. We're here for a lien law presentation, and let's talk about attorney fees. Many contracts between a property owner and a general contractor or just a contractor contain a prevailing party fee provision. And there's an example in front of you, and that is the attorney fee provision would read something like: the prevailing party in any dispute, suit, action, arbitration, or other proceeding arising out of or relating to this contract shall be entitled to recover from the losing party its attorney fees, expert fees, accounting fees, and it goes on. If you're a party contracting with the owner, then I would recommend you consider deleting that provision in the contract. Why? Because once your project is over and once you've been paid, then really that attorney fee provision is just mostly going to be a tool or a weapon for the owner in a potential defect claim. It can also help you if an owner is making a bogus defect claim, but really we litigate these things, and we find that typically a contractor is going to be in a better position if they don't have an attorney fee provision in the contract with their owner. Now, and that's because you have lien rights. And a lien is a powerful, powerful weapon to have in a payment dispute. And I think it may be the most powerful weapon. I litigate all forms of disputes in a construction project, all forms of payment disputes. And lien rights, when a contractor has properly set up their lien rights, they really do have a strength in that position. So that's why we recommend, if you're the contractor with an owner, to eliminate the attorney fee provision, because you're able to recover attorney fees if you win on your lien claim. So your lien or bond claim, those are your tools to recover your payments, and those are tools that provide attorney fees. And you're only going to be prosecuting a lien claim if you are not paid. That's the only way that a lien dispute is going to arise. And so if you're not paid, then you're going to be in a position where you're going to be the one that's probably going to be able to win attorney fees if you're right about the payment dispute. So let's talk about securing your lien rights. And these we're talking about are private projects only. Okay, so what is a construction lien? It's a security interest in real property. And where does this come from? It comes from statute. And the statute is strictly construed. And there are many steps that you have to take in the statute. You have to have the right forms. The forms have to be in the right content in the right forms. You have to record them, give them, send them at the right times. If you miss all these very specific and particular requirements, then you may not be able to perfect your lien. So it's a complicated process. Once you've set up your contract, like we talked about, you've got a good contract that's clear, and you're doing good work on your project, then you're setting yourself up to now get into kind of the process of how do I secure my right to get paid. And that's the construction lien statutory scheme and the process that you go through. And this is available to a person or entity who provides labor, materials, equipment, or professional services for improvements of real property as part of a private construction project. If you do this right, and that's you got to do it right, a lien attaches to the property, and typically that's land plus improvements. And your lien can have priority over other types of debt. For example, if there's a construction lender out there, if you start doing your work before the loan is properly recorded, and you follow your lien, steps properly, and you perfected your lien, you prosecute your lien claim, you can actually have priority over that. Ultimate remedy at the end of a process. Again, this is a process to secure your rights. So what happens is, if you follow the lien statute, you still are not paid. Now you have a tool to hire a lawyer to prosecute and foreclose your lien claim. And at the end of that process, if you are successful, then what is going to happen is the court is going to give you a remedy, which is a forced judicial sale of the property that you've liened, with the proceeds being used to pay debt, meaning that your unpaid bills. And the prevailing party may have right to attorney fees. There is attorney fee recovery in the statute. You can lose attorney fee recovery if you don't properly follow the statute. As I said, a lien must be perfected by following requirements, and it's based on the type of project and claimant. Lots of different requirements, very complicated. And I think if you just walk away knowing that, look, you've got to make sure that you're going to the right sources for help before you start your construction project, to make sure you're organized to get all your steps in place for securing your lien rights, then really I think I've done my job, because it's too complicated. You can't take notes and figure this out through a webinar. So again, as a reminder, when we're talking about liens, we're talking about private construction projects only, and it's labor, materials, equipment, or professional services for the improvement of real property. So some lien basics, again, big picture things here. A lien is measured by the contract price for the work, which is why when we were talking about contracts at the beginning of this webinar. So what you set up in your contract is going to now be impacted by how your lien is measured if you're in a lawsuit. And that's obviously got to be work that's authorized by the owner. That's a loaded term with lots of complicated permutations from there. And it's got to be on an improvement defined by statute, and that's in most cases the lot, tract, or parcel of land which is improved. So what about bond rights? And those, there are bonds for private projects. What I'm talking about here specifically, though, are bond rights on public projects. And in Washington federal law, they require prime contractors to furnish payment bonds to secure payment rights of suppliers and subcontractors. So who are claimants under a payment bond? And that's again by statute. And those are laborers, mechanics, and subcontractors, and material suppliers, and all persons who supply such person or persons or subs with provisions and supplies for the carrying on of such work. There is a pre-claim notice process for bonds, and that's required for all potential bond claimants not directly contracting with prime contractors, with the exception of laborers. And the pre-claim process, big picture, claimants got to sign a written notice of claim, and the form is specific and it's prescribed by statute. So if you go to a resource like SunRay, then they have forms that they've already made, that are based upon the statutory form. What you don't want to do is create your own form, make something up. You want to go to the right form, start in the right place, and that is prescribed by statute. And again, an entity like SunRay is going to know which forms. The claimant then presents and files a notice of claimant with the correct recipient. And again, there's too many permutations for me to just list them all. But for example, a board, council, commission, trustee, but it's got to be the proper recipient. Then the written notice has to be filed within 30 days from and after completion of the contract and acceptance of the work by the affirmative action of the recipient, meaning you got to send it to the right person and they've got to give you affirmative action about receipt. All right, let's talk about some rules and exceptions. Lots of traps in lien law, lots of traps for lawyers, and especially, important as a contractor who wants to get paid. The easiest thing to remember is quite simply go to the right resource before you start, because those folks have all the right tools and then use those tools as you go through the project. And of course, that's after you've properly set up your contract, which is the first step. All right, so there are pre-claim notice requirements for liens, and they vary depending on the kind of project. So for example, commercial projects, pre-claim notices must be given by material or equipment suppliers who do not contract directly with the owner. Also, subcontractors who do not contract directly with the prime contractor. Then another example for pre-claim notice requirements are owner-occupied single-family residences. Pre-claim notices must be given by persons or entities who do not contract directly with the property owner. And there are exceptions to this as well. For example, persons whose claim is solely for labor. And then another example, first-tier subcontractors who contract directly with the prime contractor. And those are all kind of loaded terms as well. Pre-claim notice form and delivery. So it's again statutorily prescribed, and there is a form of notice given by statute. And again, SunRay has that form. Don't create it yourself. You can also pull it off the statute as well. Notice is given to the owner or reputed owner. Again, in a those are some loaded terms. Notice is given by certified registered mail or by personal service. So you have to get the right notice, you have to give it to the right person, and you also have to do it the right way. Otherwise, you could lose your right to your lien. Pre-claim notice timing. This is also a very important point, and there's lots of fuzzy gray areas that we operate in. But let's take commercial projects. Notice given within 30 days of starting work, supplying materials, or supplying equipment will preserve the lien right for all work, materials, and equipment furnished. You can give notice after that, but you're only going to preserve part of your lien rights if you do so. So give your notice within 30 days, within 60 days. Now, what about single-family residence? Again, that even has different answers. But for new construction, you want to give notice within 10 days of starting work, supplying materials, or furnishing equipment. Occupied single-family residence, you want to give notice prior to the time the owner-occupier pays the prime contractor, and that ensures that you're protected on your lien claim. So another, important point is you've got to file or record your lien within 90 days. Within 90 days of what? Well, it's 90 days after you cease to furnish labor, equipment, or materials to the project. Now that's a big fuzzy thing. I always, in a perfect world, you'd want to calendar the day that you start work on that project. You want to know when 90 days comes. That doesn't mean obviously that you're going to lose your lien rights at the 90th day. But if you really want to plan and preserve your rights, you really want to keep very specific track of this number, because sometimes it's going to be unclear about when did you cease to furnish labor, material, or equipment. That becomes big disputes. It gets litigated heavily, and it can be unclear all the way through even the lawsuit. So if you can file and record your lien, within 90 days of when you started, obviously then you've got it timely. But otherwise, you want to keep a close eye on when maybe it's the first big gap in your work, and you want to be really careful and preserve your lien rights. This is very important, this 90 days. Form and delivery of lien claim. Again, the statute's very specific about how you do that. And you've got to follow the form prescribed by statute. Again, SunRay or statute can give you that information. Then after you file and record a lien, the lien claimant, you've got to provide a copy to the owner or reputed owner. You've got to do it by certified or registered mail or by personal service within 14 days of filing the lien. And that's got to be all done properly, or you could lose your lien rights. Then once you've properly recorded your lien claim, now you're kind of in the driver's seat. Okay, if it's set up right, then the next step is to either get paid or to get a lawyer and have the lawyer foreclose on the construction lien. And if you've done your job right, if you've set your contract up right, if you've secured your lien rights properly through the process, you are in a power position. And you're able then, you don't actually have to have your lawyer at that point in time, but you can know that now you're going to be in a position where the other side may have to pay your attorney fees if you have to file your lawsuit. So you're shifting the power into your court. And this is the time to now negotiate. You have 8 calendar months after the lien claim, the date the lien claim is recorded, to file the foreclosure action. Go to your lawyer 30 days before, please. Do not go to your lawyer the day before, 2 days before. You want to give your attorney enough time to get this properly set up for you to secure your rights and for you to get paid like you should. But in that 8-month period, that's your time to get paid, and you can try it yourself and bargain because you're in the power position. All right, lien law traps to avoid. We've got, I think I've touched on this. You don't want to waive your lien in the contract. We've talked about pay if paid and pay when paid provisions. I'm using legalese right now. I may not be connecting with some of the folks when I talk about these terms, but if you look at some of the big general contractors in town are going to have these provisions in there. And if you're a sub, you may not be able to negotiate, but beware of them. And those are a provision that basically says the general doesn't have to pay the sub until the owner pays the general. That's a pay when paid. A pay if paid is you don't get paid at all, subcontractor, unless the general gets paid by the owner. And so you don't want those in your contract if you're a sub, if it can be avoided. So don't give up your lien rights in advance. And I've talked to you, there are also many of these contracts have notice provisions in them, and that is during the project. There could be some onerous contract terms, especially from some of the bigger contractors in town that have onerous hoops you've got to jump through all the time, and you've got to do that, though, especially if it's about notice of claims during the construction process. And I'm not talking about lien claims. I'm talking about a notice of claim in your contract with the contractor. Follow the notice provisions. Otherwise, you may lose the fight about the lien. You want to make sure you're registered as a contractor prior to entering into your contract. Don't let that lapse. If you do, you may be totally out of luck. The right way to release, to exchange or release for a check, you want to have the phrase "we recommend to the extent of payment." So generally, an owner wants to make sure it's not going to have to make multiple payments when it writes a check. So that's their point of view. And then attorneys may be telling the owners to get full releases of any and all claims, and which, we say contractors, you probably want to avoid trying to do that. But owner just wants to know they're going to just have to pay once. From the contractor and supplier view, well, they want to get paid, and you want to preserve pending and potential claims to the extent that you can. And a lot of words on this slide, but here's you've got conditional and unconditional lien releases. Conditional release is prior to getting paid, and a unconditional release is after payment's been received. But we recommend, regardless, a lien release should be, quote, to the extent of payment, end quote, and don't do a broad release of something like this, all claims as of the following date. You don't want to do that because you may have just burned your lien rights for future payments on this project. Okay, so that is that's where we are, and I guess I turn this over to you now, Jesse.
Yes, thanks so much, Chris. That was amazing. You went through a lot of information, but it was really important, so thank you so much. We do have, pardon me, we do have a question that has come through. It says, how long is my lien effective for?
So if you've recorded, so all these steps, you go through the pre-claim notice, now you have a claim, you've recorded your claim. Once you record your claim, you have 8 months to file a lawsuit. If you don't file a lawsuit in 8 months from the recording date, you've lost your lien rights.
Great, thank you so much. I appreciate that for that clarification. And I saw this is another question, and that's about their posing, but you kind of addressed some of this in that last slide that we just went over. And it says, does Washington have a standard form for a lien waiver? And is there language in there specific to conditional or unconditional releases?
Well, I don't know if, okay, I do know there's one available on the for attorneys access at the Washington State board, but I don't know if the public can access that or not. But I do know, yeah, there are forms that people use, and you know, if I can provide more information on that, Jesse, maybe afterwards.
Okay, perfect.
Because I know I can access it, but I don't know who else can.
Okay, great. Well, thank you. And just to keep an eye out, you guys, make sure that you guys are reading those releases and selecting the correct language to be a part of it, so it doesn't end up burning you in the long run. That is all the questions that have come through. If anyone does think of any further questions that weren't addressed, please feel free to reach out, and I will be sure to answer questions as soon as possible for you. Chris, can you go to the next slide for me, please? All right, so who is ready to win a little gift? We're going to test your knowledge and your skills. If you're able to answer these questions correctly, please put it in the chat, and I will be sure to send over a little SunRay gift for you. When is the deadline for a subcontractor or supplier to file a notice to owner or contractor in Washington? And then the other one is, what is the deadline to file a Washington claim on lien on residential or commercial projects? If you feel like you know those answers, please write it in the chat, and I'll make sure to send you guys over a little gift to you. Go to the next slide for me, please. All right, so here are some of our SunRay resources that we have available for you guys to stay organized. Go ahead and scan that QR code. You'll be able to have access to our deadline calculator, project information sheets, your state lien law rules. So if you've got a project in a neighboring state, that state might have very specific lien laws that are different than Washington. So please make sure you're checking that out. Make sure that you guys have the right documentation and the right deadlines in mind for those jobs. So go ahead and scan that QR code to access all of that information. Go ahead and go to the next slide for me, please. All right, so we have a new service available at SunRay. It's SR Receivables. We're going to help you guys with your collections as well. We're here to help you guys get paid. So if you are interested in learning a little more, give us a call, send us an email, and we will go ahead and help you out with that as well. Go to the next slide, please. All right, our next webinar with Chris about Washington lien law is going to be on October 8th. It's don't sign and release unless it says this one thing. So go ahead and register for free for that. It's at sunraynotice.com/education. We hope to see you guys there. Next slide, please. All right, this is a Google review for us. We love to get your feedback about the webinar and what we can do for you. It really helps us improve ourselves and make sure that we're reaching more contractors and suppliers like yourselves. And then the last slide, if you don't mind. All right, and with that, that is all we have for you guys today. Thank you so much for everybody who attended. We hope to see you guys at our next webinar. Thank you again, Chris. You were incredible, and I hope you all have a wonderful and sunny day.